Thank you very much. Welcome everybody, both online and in the room. As you know, the Sherrard conversations, and this is one of them, are intended to tackle legal issues which are of wider relevance to society. Now, admitted, arguably, all legal issues are of relevance to society, but some perhaps more obviously so than others. This evening's topic is violence against women and girls and the criminal justice system. I think we can all agree that this is an area of great concern, and certainly of concern for more people than just lawyers. And it's my very great pleasure this evening to introduce you to Harriet Wistrich, who is a solicitor and the director of the Centre for Women's Justice. And she will be in conversation with Professor Nicky Padfield, Master Padfield, to those of us who are members of the Inn, who is the chair of the Inn's Education and Training Committee, and suggested that this would be a good topic to tackle this evening. So over to you. Thank you very much for making the time, and we look forward to hearing from you.
Thank you very much. I'm not sure it's so much a good topic as a sort of necessary and horrible topic, but a topic that we certainly can't afford to ignore. I'm really pleased that Harriet's here, and she's sort of a bit of a hero to me, and has been for a long time. I checked up on Wikipedia, as we all do today. Yes, she's the director of the Centre for Women's Justice, but I think that I probably first came across you with Justice for Women back in the 90s. And I think law students probably still study Sarah Thornton's case, don't you? And Karanjot Aluwalia and Emma Humphreys, they're still law reports. But of course, to Harriet, they're human beings and they're not law reports. Emma Humphreys, you wrote a book about, didn't you? Which was, she had such a tragic life, and so many of the women's cases who you've been involved with have extraordinarily miserable lives. And I think it's really easy for us, either as academics or as barristers, to forget the reality of what's going on out there. So I'm really grateful. I don't know whether Justice for Women still exists or whether it's sort of got transmogrified into the Centre for Women's Justice. The Centre for Women's Justice has a fantastic website, if I can do a plug for it before I hand over to you. Their vision, a society in which all state institutions work effectively to eradicate male violence against women and girls. Our mission, to hold the state to account and challenge discrimination in the justice system around male violence against women and girls. They sound a bit like essay titles to students, discuss effectiveness or whatever. There's obviously a huge amount to discuss there. Last year, I met Harriet again in relation to a fantastic report which they produced last year, Women Who Kill, How the State Criminalizes Women We Might Otherwise Be Burying. And there's plenty of food for thought in that. This is a Sherrard conversation, so I hope mostly what we'll do is have a conversation. But in order to have a conversation, I think it's important that Harriet gets a chance to set the context of the conversation. So over to you. Thank you hugely for being here. And I'm sure that this is an audience which wants to listen to what you have to say.
Well, thank you very much, Nicky. I thought it might be helpful to give a little bit of an overview of some of the issues around violence against women in the criminal justice system. The last year has been probably one of the biggest national conversations we've had, particularly following the disappearance of Sarah Everard and this subsequent discovery of her murder, and then the subsequent further discovery that that murder was perpetrated by a police officer. This and a series of other events really have kind of put violence against women and girls onto the national agenda in a way that it's rarely been so much talked about. As an organisation working very much around the issues that kind of fed into that national conversation, we were being approached a lot by the media and even by some government ministers and stuff to say, well, what do we do? What can we do to tackle violence against women? What needs to change? And because this kind of question kept being asked, I decided to write a sort of manifesto, if you like, a Centre for Women's Justice manifesto about what's wrong with the criminal justice system and what needs to change. And that's sort of that's part on our website. In fact, I'm doing it in installments every week. I'm trying to write an episode every week. I'm on to just published episode 3. I'm kind of filling in, kind of really trying to pulling it apart and from the experience that we have. So, and Nicky's described what our basic mission is, but the way that we do that or aim to achieve that mission is sort of we're in 2 different directions. One is that we work with frontline women's organisations, so organisations like Rape Crisis or Women's Aid and other organisations that work directly with victims and survivors of male violence. And our aim is essentially to help train those organisations, make them aware of what the actual law is and what the duties are prescribed through policies and guidances of policing, Crown Prosecution Service, and so on, in order to do the job that they're supposed to do to actually enforce and implement the laws. Because what we see is that there are quite a good set of laws around violence against women. They're not perfect. There's always areas for improvement, but what we also see is that they're not being implemented, and it's that failure to implement the laws really that is our kind of key focus. And so by training the frontline organisations, this is across the country really, we then also offer a response. So where they identify, they seek to advocate more effectively by reference to the law. Like, hey, there's a victims' right of review. The police haven't given that to somebody, so assistance with that, or what the police should be arresting for coercive control here, and you completely missed looking at the pattern of abuse, those sorts of things. And so we're trying to make the frontline advocates more effective, but where they hit a brick wall, they come back to us with inquiries, and then we identify whether it's an issue that we can easily help. We have a lawyers panel, and we have quite a lot of barristers on our panel actually, as well as solicitors, to whom we refer cases, or sometimes we seek pro bono advice on a particular issue. So that when a complex issue arises, for example, multi-jurisdictional issues, like, well, what happens if the rape takes place in another country? Can you ask the police to investigate? If it's in a different country, or if the perpetrator is now in a different, those sorts of issues, or whatever they are. So we ask, and then we try and help provide legal remedies, often through referral, or we do have at the moment a small litigation team of 2 plus me, and we seek to identify potential cases for strategic litigation. And take cases on. So through that work across the country, we identify the sort of systemic failings that we see. So one such big example was a legal challenge that we brought, which ended earlier this year, unsuccessfully ultimately, but it had quite a big impact, which was a judicial review of the Director of Public Prosecutions, was responsible for the collapsing volume of prosecutions of rape. So rape prosecutions have sort of hit a whole all-time low. And why was that? And we had identified, partly through being fed some information from a whistleblower, and also through other sources of information, that the CPS had quietly abandoned something called a merits-based approach, which was a guidance about how you made decisions about the prosecution of rape. Because obviously rape is a notoriously difficult area to prosecute where you're looking at the issue of consent, because you know, if it's the kind of classic one person's word against another, you know, in what basis do you decide whether to you know, that it passes the realistic prospect of conviction test, and that must be not a second guessing what a jury might say. So it's not a bookmaker's test; it's an objective test based on the evidence, which is what the merits-based test was designed to do. So we felt that there was a link with their quiet removal of this test. In fact, ultimately, and the case went to the Court of Appeal. The case was dismissed, and we weren't able to take it any further. But in fact, it still was highly impactful to bring that litigation, because it was a vehicle for huge publicity and disquiet, and it actually influenced, at the same time, there was a government's end-to-end rate review, and it influenced the content of that. So litigation can sometimes be impactful even if you don't ultimately win in court. That's the sort of example of what we do. But from the work we do and from all the different systemic issues that arise, we've sort of identified, I kind of have been writing kind of 10 steps or 10 things that need to change. And just to give you some headings, we don't have to go into too much detail because I'll just be talking endlessly, and you can, obviously I could talk for hours and hours about everything that needs to change, but
You've got till 7:15.
no, well, I prefer it to be more interactive. So the 10 headings I gave were: radically transform the investigation and prosecution of crimes of violence against women. So, for example, in relation to sexual violence investigations, too often the focus seems to be on victims. You know, like let's sort of get all the information we need about the victim, rather than focusing on investigating the suspect. I think that was basic, but actually, you know, women's experience of particularly of rape and sexual violence investigations is that they feel under investigation, and then the whole process becomes, you know, like their whole private life is being pulled apart, rather than you know, like, let's just find what we can on the suspect and to see whether we can prosecute. So that's an example. Number 2 was implement the existing laws and measures designed to tackle violence against women and girls. So there we're looking at all sorts of measures that are actually in place, which perhaps the police aren't implementing. And I see that somebody here is here from Her Majesty's Inspectorate of Constabulary, who is looking at our, or was looking at our first police super complaint that we did, so a police super complaint is a new device, and we've used that twice so far, and that looks at where there is not just a you know, conduct issue, but where there is a problem in the way in which policing is done. And we identified through the work we did with frontline service providers, domestic violence organisations, that the police have these powers. For example, they have the power to obtain a domestic violence protection order, and that essentially you know, continually the police are saying, well, go and get a non-molestation order, which is a civil remedy, and it means that the woman has to do all the work. She has to find a lawyer who can advise her, and so on. But actually, the police could be going and getting these domestic violence protection orders. So that's an example of failure to implement measures that are available. The third area.
Can I interrupt you there for the first time? I've been very good at not interrupting you. Domestic violence protection orders. Do you have a clear feeling as to why the police don't want them, or don't go for them, which is presumably that it's work for the police?
Yeah, work for the police, and they may not even know about them. Some of them, I mean, what's quite interesting is it's very variable. We found that there are some areas where they were using them, you know, quite regularly, and others where they were never used. And that may be to do with leadership and about how police, specialised police departments, whether they've got a special training and focus on it or not. So there's sort of big variability in the implementation of those.
As I remember, because I go back a long way,
Yeah.
They were dumper orders, weren't they? Domestic violence matrimonial proceedings or something,
Yeah.
orders in 1977.
Yeah.
And the police liked them then because a civil order,
Yeah.
somebody has to get, and then the police only have to worry about proving the breach of the order,
Yeah.
which is, of course, we've had the same problem with ASBOs and all sorts of
Yeah.
other things,
Yeah.
which are deeply problematic. But in theory, you think the domestic violence protection orders should work better?
Well, they should be used, at least, because also,
Do
of
we get
course,
statistics published on how much they are used?
yes. Well, I think the report found that they were used in about 1% of cases where they could be used, so not very often. In fact, we're now moving to, we will be under the Domestic Abuse Act. We've created something called DAPOs now, Domestic Abuse Protection Orders, which are going to be coming in to replace domestic violence protection orders. But, we kind of think, well, what's the point of these if you can't use them anywhere?
Question of repackaging.
Another part of our police complaint, since you mentioned the civil remedy, non-molestation orders, is that the police don't arrest for breach of non-molestation orders when they should do. So that's another issue in that civil complaint. So
That was number 2 of 10.
very quickly, end criminalisation of victims of abuse. So I've just published that today, actually. But that's really when a victim of abuse, because of the circumstances of abuse, ends up committing a criminal offence. And the question is, should they always be prosecuted? And too many women are prosecuted. We know women's prisons are full of women who have been, victims of domestic abuse. Sometimes, that because a crime has been committed as a direct result of being subject to coercive control or defending themselves against a violent act. And again, we kind of go through that in quite a lot of detail. And Nicky mentioned the Women Who Kill report, which, if you're interested in that area, so we published this big piece of research on women who kill. It kind of, if you look at that, it kind of tells you really the whole story about what's wrong with the criminal justice system, and not just for the very small number of women who end up killing their abuser, but across the board. The fourth heading is about police perpetrated abuse, tackling police perpetrated abuse. And again, in fact, our second police super complaint is specifically about that, and about the difficulties that a woman who is in a relationship with a police officer will have in reporting domestic abuse, and particular problems also for police women who are sexually harassed or are in a domestic abuse relationship with a fellow police officer. And that of course is a very topical issue with the post Sarah Everard case, a lot of media interest suddenly in police perpetrators, and what is being done about them. The fifth area is about ensuring that criminal justice agencies are properly accountable, and that is, although there are quite a lot of mechanisms for raising complaints about police, it's more difficult, much more difficult to hold the Crown Prosecution Service to account, which is a particular pet subject of mine, particularly after we finally failed in our challenge of the DPP. And of course, it's just also about sorts of legal remedies that are available to challenge state institutions when they fail. And as we all know, there are kind of current potential threats to some of the key remedies, judicial review and Human Rights Act from the current government, which is concerning. The sixth area is understanding the problem properly through research and the publication of meaningful data. So, obviously we can't really tackle a problem effectively if we don't have data in which to identify. And so, you know, particularly now, if we're looking at intersecting issues of race in particular, and disability, where there are additional barriers and burdens, it's very, very important for police and CPS and so on to properly disaggregate the data that they collect, so we may understand where the failings are happening. 7 is explore and implement reforms to the criminal court system to ensure proper equality before the law and an end to victim blaming. So a bit more, if you want. So, for example, one system we've seen that can really make a difference is specialist domestic abuse courts. So where everybody operating in the court system actually has an understanding of domestic abuse. And I mean, the stories we hear from magistrates actually about the way in which decisions are being made about domestic abusers will depend completely on the bench's understanding of domestic abuse. And of course, in the courtrooms more generally, you know, if you have a judge that you know has an actual understanding of abuse, and also you have a prosecutor who understands it, or a defence counsel who understands it, that will make a difference to outcomes. So you know, there are kind of forms that, you know, that is an interesting model. You know, proper training, clearly exploring different pilot projects. One really interesting area is about whether or not you should have some mechanism for legal representation for victims of sexual violence, not necessarily to be represented in court, but in relation to issues of disclosure, because that's become such a huge issue. So there's some pilot project, a very interesting pilot project that was done about having independent legal representation to challenge decisions about what was properly disclosable, which is a huge issue in these sorts of cases. So that's another example.
It raises really interesting questions, doesn't it, about the status of the victim complainant at trial. I spent September back doing a little bit of work in France, where you have the partie civile in a rather different status, whereas in your cases, the women are so often almost irrelevant to the process, aren't they? Which in many ways is a good system. The state should prosecute crime rather than me have to do it myself. But this supporting them and getting the balance right between saying it's all right, the state's going to do your prosecution for you, and you becoming an irrelevant person who doesn't really know what's going on. The way we support victims in court is really complex.
Yes, absolutely. And that's a kind of fairly fundamental thing, which comes on to number 8.
One of my questions might be how much training these guys all get in these issues on their bar courses, but that's for later. Number 8.
Ensure victims who do engage with the criminal justice process are adequately and appropriately supported. And that's also, it's partly about external support, but it's also about the mechanisms within criminal justice, and supported by those that actually understand their issues. So you don't necessarily want, you know, family lies an officer who doesn't understand what they're dealing with, you know. Number 9, which something we were just talking about earlier, Nicky, is understanding who represents risk and ensuring that criminal justice interventions are primarily directed at perpetrators and not just victims. And of course, here also we're looking at issues to do with parole and probation service and the prison system, and really just looking at you know, criminal justice should be about protecting victims and preventing victimization, rather than just you know, investigating and prosecuting anyone who commits a criminal offence. It should be geared and focused. You know, we'll never prosecute all crimes. It's just you know, a bit of an impossibility. But if we focus on you know, really our resources and our in targeting those that are going to represent a risk, that to me is a sort of number 1 thing. And number 10, which isn't very filled out yet, so is related court and justice processes. So ensure consistency. There's some interesting inconsistencies in the understanding of what rape is or coercive control is, as between the family courts and the criminal courts, for example. Or, occasionally, one of our concerns, and this is the second part of the thing, is where, certainly coercive controllers can become very adept in using legal processes to continue to persecute women even after they've left the relationship. And we see this with victims of abuse who might try and speak out about it to share their experiences and suddenly find themselves in a libel action. Once you're in a libel court, you don't necessarily have any understanding at all of the of the abuse issues. A libel judge is very unlikely to kind of have that kind of focus at all. So that's a final thing I've thrown in there.
Okay, you've got a nice question online. Do write your questions in the chat, because it's nice for me to think about them and throw them to Harriet at the right place. So we will invite you, those of you who are online, to speak through this magic box on this table as well. So I don't know whether, I've just lost who this person is, Caitlin Donovan. I don't know whether you want to ask your own question. Put your mic on and start talking if you do. But Caitlin asks you whether there needs to be more investment. Yes, she's coming on. Say something.
I was just wondering if you thought there needs to be more investment into ISVA programs given the current patchwork nature of them nationally, because I had the opportunity to sit on a CPS public scrutiny panel in the Northwest, and it seemed that the use of ISVAs massively improved the likelihood of cooperation between survivors and police and eventual prosecutions arising.
Yeah, so I don't know, does everyone know what an ISVA is? It's an independent sexual violence advocate or advisor. The term seems to be used differently in different areas, but essentially they're a fairly recent creation, and they tend to, they tend to be based within projects that support victims of rape. So, particularly rape crisis, but sometimes they also exist within local authorities and others. And they will be there to basically, once a criminal justice process starts, they'll be there to help, to assist a victim through the criminal justice process from start to finish. They are a good thing, but they're a variable thing. And one of the big difficulties, particularly around sexual violence, is that they're not allowed to actually discuss the offence. So they provide general support about the process, but there's this sort of huge worry that anything you discuss then becomes disclosable in criminal proceedings. So if notes are made about this is what she tells me happened, that then suddenly becomes another thing that kind of gets thrown across into the mix of disclosure. There are big issues also around therapy and whether or not women are if they want to go for therapy whilst they're waiting for a rape trial to come up. There's a kind of, people are very wary about actually discussing what happened because again the therapy notes might become disclosable, and the way in which defence works is to try and find, if it's a consent case, is to find any inconsistencies. So it's problematic, and I think there is a need potentially for change, but it is definitely a good thing, I think, to be able to have some support as you're going through that system.
Natasha Kirkpatrick says having specialist courts to deal with sexual violence is clearly beneficial, but the juries are not trained in the same way. Rape myths are still believed. Do you think there is scope for non-jury rape trial?
Yes. Well, this is a kind of, a clearly controversial kind kind of idea. And I think that it would be worth exploring alternatives to juries in relation to rape. Just because I do think that, unfortunately, rape myths are so deeply embedded that justice is rarely delivered. And, you know, all the things that have been done to try and make that fairer, including, you know, providing guidance on myths and stereotypes and training everyone in the system, none of it seems to have fundamentally kind of addressed that issue. So I think it is highly controversial because the jury system is so fundamental to our notion of what is fair and right in criminal justice.
And there are so few criminal barristers who want to knock it.
Yes.
Interestingly, there's a question over there from here.
A bit of a legally, I guess, sort of specific question, but obviously.
Can you shout it so that the
of
online
course.
people can hear, or else I can replace it, repeat it, but it's nice that you shout it.
About sexual violence isn't really the vibe today, but like, so the laws surrounding specifically rape.
Yeah.
I think it wouldn't be a huge pain in the broad brush to say are incredibly archaic.
Yeah.
And obviously you spoke to the high standard of burden of proof and why in this specific crime it's not going to cut it. You know, in my lifetime, rape against a spouse was still legal. It's only been made
Rape
against
against a
spouse.
Yeah.
It's only been made an offence within my lifetime. You know, that is archaic.
Yeah.
And so I guess the question I'm asking you is, do you think the laws need to be rewritten? You know, if we're saying that actually eradicating jury trial, that's going to undermine the rule of law, it's going to undermine the basis of our democracy, fine. But do you think the actual legislation needs to be completely overhauled?
So if you couldn't hear the question, it was basically, early on, I think you did say something about how the law isn't too bad. It's the application of the law that matters. Here's a question challenging you on whether you really think that our definitions are appropriate for today.
I think that's an interesting question. And I'm not convinced that kind of further tinkering with the wording of the legislation will make much difference. I mean, do you think there's I mean, have you got an idea of what you think would improve
I'm
it?
just a PTC student.
Consent is deeply problematic, I think, the way we define
Yeah, I mean,
consent.
because the notion of consent is somehow wrong. Because, you know, you shouldn't. It's not like you kind of just, okay, I consent to having sex and being penetrated or something like that. It should be, I positively want to engage and enjoy, and that sort of, you know, it's the idea, and I don't know whether you could define it in a different way that would make it, you know, kind of more relevant, and kind of move away from, you know, anything we interpret about somebody's behaviour. I mean, there were some important changes, I think, within, you know, under the 2003 Act, to try and improve that. So there is a part of the statute which says you've got to actively. It's not simply a question of did she consent. You know, what steps did he take to ascertain that she was consenting, which sort of puts a bit back. But it's not doesn't really seem to get interpreted.
And in the burgeoning field of trauma-informed theory,
Yeah.
right? And when you look at sexual assault survivors who haven't realised until years after the fact that they did not get it, it's very interesting to navigate legally.
Yeah, absolutely. Yeah.
I'm going to take two more questions in the room, these two, because they've both had their hands up for a long time, and then I'm going back online for a minute. So you first, perhaps you ask your point, and then you at the same time, and then Harriet can respond to them together.
Yeah, thank you firstly for your time, because so far it's already been really interesting. And just following on from this point, do you think in the alternative of abolishing jury trial, which I certainly feel very uncomfortable with, do you think seeking juries to give reasons for their decision might be a better alternative, be it just in rape cases, in all sexual offences cases, or, I mean, some barristers and specifically called for it to be across the board, the juries have to give reasons for their decisions, because that way you might be able to elicit whether there has been these kind of rape myths or kind of biases about what is a victim, what is because there's no one single victim of sexual assault. There's no kind of stereotype. Just in the same way, there's no one single stereotype of the perpetrator. Do you think asking juries to give reasons might be?
Yeah, might make them try to justify their decisions sometimes. Yeah, I just thought he was too good looking, and I didn't want to ruin his life. Kind of reasons. At least then we know, which is obviously something sometimes. But yeah, it would be that's an idea, isn't it? I mean, I think that in the inquest system where we have, obviously that's an inquisitorial process. It's not about apportioning blame. But you do have this sort of questions mechanism whereby you can have juries have to explain, how they got to that point, or they answer a set of questions. Now, asking a jury to do a free form narrative with collective writing is quite tricky, isn't it? But possibly a series of questions.
Their route to verdict.
Route to verdict type thing.
From 0 to either guilty or not guilty.
Yeah, it would, be again, there's sort of pilots you could do, really, isn't it? Just to sort of see where that took you. Right. Back row over there.
First of all, this has been so interesting. Thank you so much. But my question was kind of about, we've looked at all the issues to do with the police, all of the issues to do with the courts, and I'm sure there's more that we just didn't have time for. But how do we kind of try and restructure society at large's opinion on rape, and the things we've been talking about, like rape culture and things, rape myths and things like that. My colleague and I were just talking about Catherine Oates last week has alleged that Boris Johnson's father raped her, and all the press has been about her sexual behaviour in the past, and that's one of so many examples I could bring up. So how can we start to bring about a change in the way society looks at these things? And because maybe that could help as well.
Well, that is obviously the background, isn't it, to all of this? I mean, as long as we have a misogynistic culture, then all the players in the criminal justice process will absorb those cultural beliefs and play them out. So, of course, that is a fundamental thing that needs to change as well. And that's a big question as to how that change comes about. I mean, obviously there are things to do with education and public health. It's a public health issue. So should you invest the sort of resources that have been invested, like to stop smoking, which has been quite effective, or get people to wear seatbelts, which is quite effective. It's a public safety issue, just to start really educating the public. But it's a complex issue because it's actually rooted. It's not just about let's make women safe. It's actually rooted in fundamental structural inequality between men and women, and about vested interests in maintaining that inequality, which is something quite fundamental to address.
It's fascinating because I did my dissertation on the way sexual assault is looked at in the media, and the linguistic devices that papers often use. What I found was, and my tutor and everyone agreed, was that it kind of, there's such a subtle hint at disbelieving the person bringing forward the allegation, but it's so subtly done that I think papers get away with it day in, day out, but it's incredibly frustrating once you've noticed it.
Tanya Fitzgerald, do you want to come in, because you've got some interesting questions, comments on gender-based violence, which would come better from you probably than from me, if you'd like to speak out. It's flowing in the chat, and the people online are also chatting with each other, which is good, responding to each other. Tanya.
I just want to say it's been an incredibly interactive session on the chat. Like, for all the qualifying sessions I've attended, we've never had this amount of interaction, so that means we're very interested in what you have to say. My question was just regarding what I have noticed is that there are little blips in the system that constantly undermine how violent societies is towards women. For example, well, the example that I gave was that GHB, despite being known and for rape cases, is still a Class C drug, which is less serious than, for example, marijuana. And I just feel like one of the many statements that law has with regards to gender-based violence, like this is less important than any other issues that we may have in mind at the moment. So I was wondering what you thought about these intricacies in the system that are not good.
You mean essentially date rape drugs? Is that what
they
you mean?
should be tougher on
Yeah, I absolutely agree with you. I think they're evil, and they're becoming incredibly widespread. I mean, there was even some news story that recently about injecting women. So women are sort of in nightclubs are kind of now getting wise to protecting their drinks, which was ridiculous, and so now they're finding other ways. And I mean, it's a very, very evil crime to deliberately drug somebody so that they're incapable and then rape them, and it should be treated as a very serious crime. And it's also an indicator of a serial perpetrator, because there are men, obviously John Warboys, the taxi driver, is a prime example, but there, we see these cases again and again. So when we get all these cases where the Crown Prosecution Service is saying, oh, not realistic prospects of conviction, what they're talking about is the fact that women don't remember what happened. So how are they going to prosecute this guy if the date rape drug has disappeared from their system, which it goes out very quickly. So if you don't realise after you've been attacked until the next day, and you go for a test, stuff's not necessarily in your system. So what proof have you got that's happened? And we see so many cases dropped of date rape, and you just think this man is getting away with it again and again, and is able to attack women over and over. So I think it should be a very serious drug, offence. Yeah.
Two more in this room, you and then you. Sorry, you two came in too late. You two next.
Yeah, I just wanted to go back to the idea of abolishing the jury when it comes to these criminal trials. It's something that I've read about, and I've seen the idea put through. But do you feel that it is rape myths and the jury, or is it the fact that the criminal trial is about collecting evidence? And rape and domestic abuse and a lot of these crimes are often very private things, and I feel like you cannot really collect enough evidence, and as you said, the CPS often don't feel like you have enough evidence to convict. Because, I read recently, a year ago, the Moyano report. A lady did research into actual juries rather than mock juries, and found that the average juror don't really hold those severe beliefs that people have about women. I completely agree that we live in a misogynist society, and I would say that our society hates women, but I feel it's more the system that we've built rather than people. I feel our system, almost violent people, when it comes to coercive behaviour and stuff, they've almost evolved to move out of those, to step around the things that could get them.
Professor Cheryl Thomas at UCL has probably done more research on real juries in this country than anyone else, and she certainly concluded in her more recent research that juries needed more training in challenging their assumptions. Do you want to say anything on that before?
Yeah, I mean, I think the reality is that the rape cases that actually get to trial, by that stage, they've got rid of any case that doesn't have enough evidence. So all the cases that go to trial, I don't think that's necessarily the issue. I think it's difficult. Obviously, if you've got a case where you've got, it's around consent. So you've got, it's essentially two opposing views, and a lot of the evidence happening in private. Then they are difficult to prosecute. But I think that's why so few cases are prosecuted.
There's something about the burden of proof, isn't there? That the judge says you've got to be sure.
Yeah, exactly.
And to be sure, I'm amazed that any jury ever convicts anyone of anything, quite honestly.
Yeah.
If somebody is disputing it, to be sure, how can you be sure? Sorry, you had a point.
Yeah, I have two aspects to this question. Are there any countries that have got relatively low levels of violence against women? And why do you think that is? And then in the same vein, are there any countries that have particularly good systems about dealing with violence against women, and what do they do differently to us?
Yeah, that's a good question, and I'd like to know more about that. I'm not aware of any countries that have a very low level of violence against women. I mean, there may be countries where they don't report it or collect data on it, but I fear that doesn't exist anywhere. But there are countries which probably have worse. Russia is probably one of the worst places in the world statistically for. They don't even have a law against domestic violence at all. So that sort of, the role of the law, not just in actually effectively investigating and prosecuting, but also in sending out a message about what is acceptable is obviously very important. But yes, I would like to know. In fact, we have just got a bit of funding now to do an international project in which we want to connect with organisations or legal organisations and lawyers in different parts of the world to kind of try and answer that very question as about what might work better, and what we can learn from each other, and also about litigation challenges and so on. Yeah.
I want to ask a question before I let anyone else ask a question. You've mentioned coercive control a bit.
Yeah.
Do you think the recent changes in relation to that have been a good thing, in inverted commas? And I wondered also whether it's fair to ask you just to comment on the Domestic Abuse Act 2021. Is it going to do anything useful?
Well, the recent changes, so do you mean the introduction of coercive control as an offence, or do you mean the recent changes to the definition of coercive control? So originally the law on coercive control, which was introduced in 2015, was you could only bring a case if you were still in a relationship with the person. And so one of the issues was the number of coercive controllers who were still kind of effectively stalking, using coercive control techniques after the relationship had ended. And, an example which I gave earlier was where they use family court system in particular, to continue to control the woman. And that's been amended now. I do think it's a very useful definition, coercive controlling behaviour, and it opens up some possibilities. It's not prosecuted nearly enough, but I think it has been a really important development, and it was also something we've looked at in terms of defences. So in the Sally Chelland case, which I was involved in, we specifically kind of ran the case around the developments of our understanding about the nature of domestic violence, and that she was convicted prior to an understanding of coercive controlling behaviour, which was particularly, the kind of particularly fitted her experience, if you like, and that actually that assisted in understanding why she acted in the way she did ultimately. So I think yes, it's a useful development, but there's a long way to go. I think in particular, as it's formulated, it talks less about sort of victimology and more about it's almost a political concept in its original conception, and it's about entrapping women and denying them liberty, and it becomes, as a pure idea of understanding what domestic violence is about, it's very helpful, I think. So yes, I think it's an interesting development. Domestic Abuse Act also introduces some new provisions, some of which are potentially helpful. It also has quite a lot of limitations and has failed to do other things. So yes, I think, you know, that although, you know, with the caveat,
we do have a domestic abuse commissioner, and that depends very much on the character and personality of the individual, in a sense. It's like having a victims commissioner.
Yes.
There are good ones and there are bad ones.
Yes.
And we can all have our views on which are the good ones and which are the bad ones.
I mean, you know, it's only so much any one person can do in a role. You know, certainly the current victims commissioner, Vera Bird, has made quite an impact with some of the work that she's done, and has used that role quite effectively, I think. And the domestic abuse commissioner is a woman called Nicole Jacobs, and I think she comes from the domestic abuse women's sector, and she's certainly got a good general understanding of the issues, and I think she's sort of quietly beginning to make some impact. I was just talking to Nicky earlier about an area we're interested in, which is creating a femicide oversight mechanism, so that you have all these deaths, murders of women, and then you have various different sorts of inquiries and investigations, domestic homicide reviews, independent office of police complaints reports, and inquests, and then all of these different investigations and operations then make recommendations, and you know, preventing further death reports. And yet, where does that all go? And you know, what does it actually prevent further deaths? Unless there's some way in which you can kind of draw that together and then do something impactful with it. And so we've been working a bit with the Domestic Abuse Commissioner to try and create something there.
Mia, we all agree with you, I think there. I might come back to that later. But I'm going to Eleanor Southern next. Do you want to ask your nice question on the Domestic Abuse Act? There's a good question coming in, I hope, from Eleanor Southern.
Hi, my microphone might not be too good, or you may be able to hear my dog. Apologies in advance. But it was in relation to the consent to serious harm for sexual gratification not being a defence. I remember the Grace Mullane case in New Zealand, and similar to, I think, a previous question in relation to dissertations and university projects, with further research into that, do you think that amendment will change the way courts deal with using women's sexual history as a almost to bolster the prosecution case and defence case, or what do you think the amendment will have the effect on evidence?
So this is a so-called rough sex defence.
Yes, it
amendment.
is indeed.
Yeah. Well, interestingly, we have been directly involved in that in relation to a case that came up after the Act. You know, the law was changed. And it's a case of a man called Sam Pybus, who strangled his girlfriend, or a woman he was seeing for sex, to death, and claimed that she had consented to rough sex. And the prosecution didn't even accept it on the basis of a pathology, kind of very dubious, I would say, pathology report, that he hadn't intended to cause serious harm, even though his hands hurt so much from strangling her, and got a 4-year, 8-month sentence, which the Attorney General then sought to appeal under the unduly lenient scheme, and we made an attempt, an unsuccessful attempt, to provide some evidence you know, to the Court of Appeal by way of an intervention in relation to that, which the court weren't willing to take into account. I think the conclusion from from that case, and is less about the. I don't think the law works. I think something else has to be done, and I think it's partly about the way in which these cases are prosecuted.
And yes, I think not calling out behaviour is important, says Natasha Kirkpatrick. Sarah Everard's murderer was nicknamed the rapist. What Mia was saying was that some universities are promoting girls' nights in. Surely this is promoting the narrative that women must also their behaviour by staying indoors rather than tackling the root of the problem here. Melanie Ben, you want to be devil's advocate, and then I'll come back to the room after Melanie's question. This is dropping people.
I've got a dodgy connection, I'm afraid. Yeah, playing devil's advocate, I was a criminal defence practitioner as a solicitor for very many years before coming to the bar, and my genuine concern is that we talk about victims rather than complainants, and there's a narrative which just because you have been arrested and charged with an offence, you are automatically guilty of that offence. And I think we need to be very careful about not trying to change the fundamental principle that underpins the rule of law, that is, you are innocent until proven guilty. The system is hugely flawed. I think you've made some really interesting and excellent points about the support that there are for women who are going through this process. But I think that we need to tackle fundamental issues of misogyny rather than just saying everybody who makes a complaint is automatically believed, because I think it was, I can't remember the gentleman's second name, Jack, there was a student who, it was disclosure from the CPS. That
Liam Allen, yeah. I think Liam Allen, yeah.
Yes.
Yeah.
The system is not perfect. And when I started out almost 30 years ago doing criminal work, we were having exactly the same debate. And I think it's not an easy answer, but I would be very worried about any system that shifted that fundamental principle that you are innocent until proven guilty. I think there are huge risks for the rule of law there.
Yeah, I mean, you know, clearly we need to maintain protections for defendants who, you know, not suggesting anything that would remove the protections, and I'm far too well aware of miscarriages of justice to ever think that we should do. And disclosure, of course, is an issue that cuts both ways, because it's been a huge issue in relation to insufficient or inadequate or failure to disclose in criminal cases, which can lead to miscarriages of justice. But you know, it is a question really of you know, getting the balance right. And you know, unfortunately, you know, whether or not we call rape victims or complainants, they are constantly in the way in which the system works, being blamed for them getting themselves raped, essentially. And there's something fundamental there that's running through the whole process at the same time as you know, needing to provide those fundamental protections. So it's a difficult balance, but we see, for example, in relation to the disclosure issue, you know, the Court of Appeal in a case called Beta James set out precisely where disclosure was relevant, and where it's relevant and where it's necessary. And we see that that's kind of written roughshod over a lot of the times in terms of third-party disclosure. So it's also about, you know, trying to ensure that where we draw these fine lines between defendants' rights and victims' rights, that we apply the rules and the law correctly.
Right, we're not meant to go on all night, and I'm going to close down the debate for the people sitting inside this laptop. You're having a wonderful discussion, and it's another plus of online learning, Krista. We've been discussing it, that you can talk during the way in which these people, I don't know whether they could also be following the chat. You two both patiently wanted to ask a question. Does one of you want to have a go?
Okay.
Very quickly.
So Do you think the justice system needs to evolve to protect some of our most vulnerable women? For instance, inmates in prisons, from men going into prisons identifying as women, and they go into a women's prison, which has happened, and they have often been convicted of sexual offences, and then they're put into a cell with a female. And also tying on to the back of that, I mean, I was reading a news article the other week where, for instance, gay women are feeling pressured into having sex with men identifying as women. And when they tried to raise this through social media channels, for instance, they actually got a lot of hate through trans rights groups, for instance. And one such thing I remember reading on there was, if they were in a room with Hitler, they would kill her rather than Hitler.
And you behind, let's just follow that one on.
Yeah, my question is relates to the role of private prosecution. I was just wondering how private prosecution has been effective in situations where the CPS decided not to launch criminal proceedings against victims or complainants. I don't know if you've come across statistics about the role of private prosecution in sexual violence cases or domestic abuse.
So two very different topics there for you. So
Well, we haven't got all the evening to answer the issue about single-sex spaces is, as I'm sure everybody knows, a highly controversial and polarised issue. We do have an Equality Act which provides for single-sex exemptions in certain circumstances in recognition of those sorts of issues about women's spaces and safety, and certainly there was a recent case that went to the divisional court on the prisons issue, which you may have seen, called FTJ, which is the court came down on the side of that the prison policy had got it right, but that actually there was a huge deficit in terms of data and understanding the risks. And of course, there within a prison system, the ability to raise issues and complain is going to be extremely limited, particularly where there are a particular sort of overriding narratives. It's a conflict of rights issue, of course, and there are rights of trans people, trans women and trans men, and there are also rights of natal women in certain situations. So without going into answering that question, I think we always have to look at the rights system and take into account the different rights.
I just say that from us keeping up with the times. I mean, for instance, the US has moved to having gender X on passports and birth certificates. So at what point does that become apparent?
Well, I mean, I'd be happy to discuss that at length, but it's a long
move on now, because I'm going to be winding it up. Did you want to say something about private prosecutions?
I mean, yes, there are some people who have tried bringing private prosecutions. It is another way potentially forward. Although recently I was advising someone who had got nowhere with the state prosecuting in relation to a historic child sexual abuse case. And then they found lawyers to bring a private prosecution of the perpetrator, the alleged perpetrator. And then the CPS, of course, are invited often in these cases to step in. And the CPS then stepped in and stopped the prosecution again. And that can happen. It's not, it's another, I mean, there's also civil actions that sometimes people resort to if they're not getting justice, and there are limitations to that as well. It's also not a prosecution.
I want to ask you what your advice is to young would-be barristers who are deeply troubled, as we all are. Like Melanie, I've been around for longer than Melanie, and the fact that the world is no safer, and there is definitely no less domestic violence than there was 40 years ago, at least not as far as I can see. All stats are deeply unreliable. The streets are no safer. If there are people in this room who really want to engage with this work, what is your sort of message to people apart from read your website?
Well, I think there is, you know, as aspiring barristers, there's a huge amount of work you can do in this area. And, you know, that certainly since Centre for Women's Justice has only been going for 5 years. And, you know, we've just expanded hugely. We have, you know, a huge amount of interest. It's a very, very engaging area of law to do as well. So it can be satisfying insofar as you're not going to be, you know, kind of deeply kind of gutted and disappointed when you can't achieve what you want to achieve. But I mean, there is lots of scope to do work, both in the criminal, you know, criminal work and civil work and judicial review to seek to hold the state accountable and also to hold perpetrators accountable. So there's plenty of scope there.
And Rachel Standish says, join the CPS and prosecute.
Yeah, you could try. You could certainly try.
I think we were meant to end at 7:15, weren't we? Yeah, so I've allowed it to go on. This is a conversation, and it's a conversation we've got to have. I'm depressed that you think that we as a society hate women when women are 51% of society. So there's something we've all got to do about speaking out, men and women speaking out, so that we don't all hate women. It's a debate which has so much got to happen. And I am really grateful to Harriet in the way that she so often leads the debate. So a traditional thank you to Harriet, and then a drink.